Morning, everybody. Thank you for joining us. Welcome to part two of our two-part series, Insular Cases, Island Consequences. This CLE is co-sponsored with the Guam Bar, and our thanks to our sister jurisdiction for partnering with us. Part one of our series was held on July 17 during an NMI bar meeting. It was presented by the NMI Bar's Insular Case Committee members. That was recorded and it was provided to Guam and NMI members, so you should see that on our websites shortly. As our members are aware, the NMI Bar ballot box is open until August 1st for a vote on whether our bar association should adopt a proposed resolution to oppose the overturning of the insular cases. This is an important issue, and we want our members to be informed on their votes on the history and context, and so the series presents a range of viewpoints on the topic. Before we begin today's CLE, I'd like to take a moment to recognize the passing of our NMI Governor Arnold Palacios, who passed away suddenly last night. This is a loss for the Northern Mariana Islands, and our thoughts are with his family, his colleagues, and our community. We're moving forward with today's program, which feels all the more timely and relevant as we consider the challenges and opportunities facing the U.S. territories. We're honored to welcome Neil Ware. You know, it's late over there, so we appreciate him and his team entertaining us today with their viewpoints. He's the president and founder of the Right to Democracy. Thank you for being with us today, Neil.
Thanks so much, Charity, for having us, and our condolences to Governor Palacios' family and everyone in the NMI during this challenging times. And I do agree that these issues are as relevant as ever. My name's Neil Weir, co-director of Right to Democracy. I grew up in Guam, moved there when I was 9 years old. My folks still live there. Get up to the Northern Mariana Islands as often as I can. And I'm really glad to have this opportunity for dialogue today. We're really hoping that it'll be more of a dialogue than just a lecture, so we're open to questions throughout. Also hoping to save some time at the end for question and answer. But if you have a question or comment, feel free and jump in. With that, I'll hand it over to my co-director, Addie Martinez-Roman.
Yes, hi. I joined the condolences for the death of the governor. My name is Adi Martinez Roman. I'm born and raised in Puerto Rico. And I joined Neil Weir in December of 2022, when he called me to explore founding this new organization, Right to Democracy. And I decided to join after 20 years of community lawyering in Puerto Rico, and several moments, historical moments that we have lived here that prove that we don't have any agency in the decision-making process of things that affect us. And we're going to talk a little bit more about that. But when we founded Right to Democracy, it was with the idea that not everybody thinks alike. And we just want to recognize that, and we recognize that from the beginning. There are different opinions of what democracy means, of what the rights it entails, and what should it look like. But definitely, when we have these conversations, we find that there are more opinions about agency, about being able to have those opinions and to make those decisions over the things that affect us. And so when we found the Right to Democracy, we were clear that we wanted the mission to be more than just litigation. We are set to build a movement to confront and dismantle the undemocratic colonial framework that impacts 3.6 million people in the U.S. territories, over 6 million in the diaspora in the U.S., with the vision that the territories and the residents should have power over the decisions that impact their lives. And we center our work from the beginning in very important values that we always share, including especially how can we respect the differences between the territories, between the people within the territories. There are very marked differences. And how we can provoke change by building common ground and avoiding toxicity that sometimes it's inherent in these processes of unilateral governance. And our team is a very spread theme of people from all the territories, from the Pacific and the Northern Mariana. We have Seno de Leon Guerrero. Seno is a teacher in the CNMI. And in the advisory board from the NMI, we have Sheila Babauta, our esteemed Sheila, and Frances Sablan. You can also see people from Guam, from the Virgin Islands, from American Samoa, and from Puerto Rico. What we have done in the past 2 years includes a lot of listening. We call it the power of listening. There is a report that has been published in our website. And we have done many dialogues and meetings throughout the past 2 years. And we have learned that there are more things that unite us than divide us, especially around the issues of the lack of agency and self-determination and powerlessness of our self-government. In all the territories, we are seeing issues of those kinds. Also, in all the territories, there are very much matters of how we protect our land and how we avoid the displacement, the continued displacement of our people from the territories to the diaspora to find a better living, right? And that displacement is destroying communities. So how to protect land and how to avoid displacement in the heart of everybody that is involved in this work. Also, how to promote sustainable economic development, because our economies are usually very extractive. So how do we promote that sustainable economic development that works well with the environment? Because we as territories are all going through the effects of the climate and the warmer weather, which makes disasters more prone to disasters, and also sea level rise and many events related to the change of climate that affects us all. And in that sense, I've come to see and I've learned in these previous years that we support many of the same things and that we can strategically leverage these shared experiences. And when I talk about these issues, I always start with myself. The experience of the Commonwealth of Puerto Rico, which is what I carry. In 1952, we approved our Constitution with this illusion or this aspiration of it being a bilateral relationship, a bilateral accord with the United States. And it was not until a few years ago, like around 10 years ago, that this bubble or this perception changed. And Neil is going to talk more a little bit about how it changed in the case Pueblo versus Sanchez Valle. But definitely another thing that we share in Puerto Rico and that I've seen in all the territories is the fears. The fears of how do we live in a system that we do not control and that is prone to disasters and that is pushed for austerity by imposed institutions of the federal government, like in Puerto Rico, the Promesa Board. And we have lived these hurricanes. We have lived more than 150,000 of our people leave our territory of Puerto Rico. And we still live on the fear of what we do to be able to change these conditions when this relationship of the U.S. also is very limited. And how do we do not affect the socioeconomic reality of people by changing these relationships? And there's always this fear, but this fear is shared through all the territories. And for us, we're going up to 2026, and it's like almost 125 years of seeing how the U.S. government keeps using the insular cases and especially the doctrine of the non-incorporated territory that it created and legitimizes to sustain the unilateral power when they want it. They never use these cases, and they have never used these cases to protect us. And Neil is going to talk a little bit more about that when going through the case law.
Thanks,
Neil.
Addie. So, last week we heard about a number of federal court cases involving the NMI in the 1980s and 1990s. Since that time, and really since I've been professionally working on these issues, it's really been more a steady trend of the United States narrowing the scope of self-government in the NMI, acting unilaterally against the expressed desires of the people of the NMI and their elected leaders. One initial example of this is in 2005 on the issue of submerged lands, where the Ninth Circuit rejected NMI claims to these lands, recognizing, quote, that the United States has paramount rights to submerged lands, notwithstanding the covenant and two laws passed by the CNMI legislature. 2007, Congress imposes a minimum wage increase over the objection of local leaders, really dramatically impacting the NMI's economy. Then the next year, 2008, Congress takes control over immigration, something that was set forth in the covenant. There was a legal challenge. Courts upheld that federal exercise of power. In 2016, Davis versus CEC, we saw the courts invalidate local laws that restricted voting on NMI's land ownership rules to those eligible to own land. And then most recently in 2025, the Supreme Court denied review in Salas versus United States, an important case challenging the ability of Congress to act unilaterally to ban cockfighting in the NMI and other territories. Now, I actually was in the courtroom when this case was being argued and was honestly shocked at just how expansive the Department of Justice's arguments were. Based on the reaction of the judges, was not so shocked by the result. For what it's worth, we also lost our case that day too. Let's dig in a little bit more to the Salas case. So after the Ninth Circuit issued its ruling, Salas petitioned the Supreme Court for review. And I'll just read out a part of that petition that I thought was particularly compelling. So, quote, the important question is the meaning of the right to self-government over internal affairs guaranteed to the people of the Northern Mariana Islands by the U.S. CNMI covenant. If the Ninth Circuit view that Congress may unilaterally prohibit and criminalize even a quintessential internal affair of the Northern Mariana Islands, so long as a hypothetical rational basis exists for it to do so, is allowed to stand, it would mean that the covenant accomplished precisely the opposite of its own stated purpose, and that the United States, by entering into such a covenant, stands in breach of its obligations to the international community of nations in the United Nations Charter and of the sacred trust it assumed towards the Northern Marianas people themselves in the trusteeship agreement. It would mean that the United States, rather than eliminating colonial rule in the Northern Marianas, has instead institutionalized it. To allow such a holding to stand would be, in effect, to hold that the United States has committed a historic betrayal of the most fundamental principles upon which it was itself founded, in the very context where those principles appear to emerge triumphant in the world at large. I found that very moving. Unfortunately, the U.S. Supreme Court did not. They denied review without even requesting a response from the United States. Going to the next slide, the United States position in that case, I think, is revealing of this general dichotomy and understanding on what the significance and meaning of the covenant was. In that case, the United States presented and said, quoted from the Senate report from 1976, saying, although described as a commonwealth, the relationship of the Northern Mariana Islands to the United States is territorial in nature, with final sovereignty invested in the United States and plenary legislative authority vested in the United States Congress. So these series of cases since 2000 to the present highlight a disturbing trend where the federal government has claimed and exercised greater control over even local affairs like cockfighting, much less more kind of broad policy issues like the economy and immigration. And so that really brings us up to where we are today. You know, when we heard the bar was considering a resolution, we had hoped maybe it would be a resolution focusing on these issues of self-government and self-determination. And instead we learned this was going to be the focus. So happy to talk more about that too. Eddie?
Yes, and we want to dig in a little bit on how we are meeting this moment because, of course, the Northern Mariana Islands is not the only one that is facing these issues of challenges in self-governance and also in having the Supreme Court and the courts of the United States just sustaining this unilateral power. So the questions that we're asking are more related to how is this power dynamic with the US structured? Even with the instruments we have in terms of like the differences of the instruments, even between the two Commonwealth, the Commonwealth of the Northern Mariana and the Commonwealth of Puerto Rico, there are two different instruments. And I was very I'm an admirer of the covenant in the sense that how it was actually a negotiated treaty with the United States. So definitely admiring that. But still, there is a power dynamic that is structured in this non-incorporated territory definition that is being used. And how is this relationship balanced and democratic? And we ask these in all these dialogues with the people of the different territories, which have different relationships or the basis of their relationship. And what can we learn from our histories and each other to promote real self-government and complete self-determination? And I think we need to start by understanding the insular cases in their context, not only in the specific case law, black letter law, but go more into the socio-historical context in order to determine how law is related to social change. Like how is this relationship brought up? Also, we will later go into how the Supreme Court differs from lower court conceptions of the insular cases. And we're going to touch upon 5 recent Supreme Court cases examining federal power over the US territories, because at the end, it is the Supreme Court, the one that establishes what is the law of the land. And to start with the context, we have to understand that from the get-go, we are in the 250th, in the door of the 250th anniversary of the Declaration of Independence of the United States, in which they found their nation based on the idea of the consent of the governed, right? But even when they were already doing the Constitution, they provided in that Constitution an admissions clause versus a territorial clause. So they would be able to treat different concepts, different ways of the territories as they would be expanding. So they were already thinking about expanding their land. And as they move through the Northwest, we have the legal bodies of the Northwest Ordinance of 1787 and 1789. And in that conceptualization of expansion to the West, Congress could not govern over these territories as colonies permanently. This expansion was thought about as the right of the white men to hold absolute title of the or ultimate dominion over the land through what was called the doctrine of discovery. And I have to say the doctrine of discovery comes from Europe, comes from the church, saying or excusing the conquest of the Spanish and others to America, the whole continents of America. The church has already apologized for that. Johnson's versus McIntosh is still not being overturned. And that conceptualization of racial superiority, even with that, still Congress could not govern over these territories as colonies permanently. They would have to be admitted. And in this, post-war amendments, it was an attempt to solve the conundrum of what to do with the Black people's citizenship and their vote. And of course, they were already thinking, how do we integrate these people into the American body politic? Because after the original Constitution and the expansion, slavery, there was still the racism very much alive, to the point that even when President Grant failed to annex the Danish West Indies and the Dominican Republic, the reason that he failed to annex those lands was because there was racist opposition that recognized that under the 15th Amendment, these people that would be annexed would eventually become part of the body politic of the US and vote. And they didn't want people of different races to be voting. And so in 1898, when there was this question, colonies or not colonies, the US decides, because it was led by President McKinley and Theodore Roosevelt, they were deciding we are going to keep expanding. And so in a matter of 3 months, they go to the Philippines, Guam, Cuba, Puerto Rico, and Hawaii. And after, of course, the war with Spain, they stayed with Guam and Philippines and Puerto Rico through the Treaty of Paris, which was debated in the Senate with a full room of white people, Spanish from Spain, and United Statesians, people from the United States, without the presence of the people from these new places that they had acquired. So it was already very heated and very exclusionary. Also, you have to recognize that this was a very heated political debate in the American scene between imperialists and anti-imperialists. And that the anti-imperialists that did not want to expand to these new places and hold them as colonies were like that because they were like, if we are going to expand into these places and be consistent to a Republican form of government, we have to annex them eventually, and we will bring more Black, colored, indigenous people into the body politic. So there was this debate based on that idea. Then that debate became academic. And in the Harvard Law Review of we had 5 articles, and there's more detail there. But one of those articles, 2 of them said were pro-imperialist, 2 of them were anti-imperialist. There was a third one, authored by Abbott Lawrence Lowell, that came with this theory that some of the territories where the US expanded would be annexed, but then the others would not, through a doctrine that would be known as the territorial incorporation doctrine. That is the doctrine that was then used by these 9 Supreme Court justices to justify the decisions that they made in the Insular cases, as it is a constitutional, it is valid under our constitutional law to keep these unincorporated territories under the unilateral, under the territorial clause which is plenary powers of Congress until Congress decides. So because of our alien race, savage tribes, and uncivilized race, the excuse at the time, which is still very powerful content in these cases, they legitimated through constitutional law the possibility of an indefinite condition of political subordination, making the US Constitution an instrument in the service of colonialism. And this is a quote from Efren Rivera Ramos, a very well-known scholar from Puerto Rico that has written multiple articles, but this book, The Legal Construction of Identity, I always recommend it to understand the relationship between case law and culture in how it affects us. So with this colonial framework, this is what we name, or this is what we call the colonial framework. We are trying to build a strategy to confront it. Litigation is just part of this strategy to confront and reckon and push for system change. We do participatory advocacy, which uses community lawyering techniques with litigation and with policy advocacy. So always participating and in dialogue with the people we are representing and that we're working with. We are pushing for narrative change and we're building an ecosystem, always in conversation. This activity is part of this. We're trying to build an ecosystem with you today, tonight. And because the insular cases, much like Dred Scott, Plessy, and the Chinese exclusions cases are examples of why we need reckoning and change. Dred Scott was changed because of a constitutional amendment. Plessy versus Ferguson was overturned by Brown versus Board of Education after a movement building, right? The Chinese exclusion cases, the most important ones, are still good law. And they are a menace today to immigrants in the United States because of their decisions. So it is litigation and movement building are and can work hand in hand. And okay, yes.
Thanks,
Neil,
Annie.
you can go and say this one.
Yeah, so wanted to talk through a little bit more to provide a little bit more clarity on, what the insular cases did and did not rule. So despite all the rhetoric in public about, the question being, did the Constitution follow the flag? That's really not what they held or were focused on as a doctrinal matter. There were no holdings in the insular cases saying that only, quote, fundamental rights apply. That was something that was interpreted later through lower court rulings, and they also didn't establish this kind of this impractical and anomalous framework. That was Supreme Court cases involving extraterritorial application of the Constitution, not Supreme Court cases involving the application of the Constitution in U.S. territories. Lower courts took that up as a way to apply it to the territories themselves. Happy to answer more questions about that if folks are curious, but otherwise let's move on to some of the cases. So, as we said, the Supreme Court heard a lot of territorial cases in the early 1900s. They've heard almost as many in just the last 10 years, really starting with this case, Puerto Rico versus Sanchez Valle. And that case was about double jeopardy. It asked, do criminal defendants in Puerto Rico enjoy the protections of double jeopardy when prosecuted for the same offense under both federal and Puerto Rican law as they would if they lived in a state or federal Indian reservation? And the court answered no, because U.S. territories do not have any sovereignty separate from the United States. And the court there said, quote, the island's constitution, Puerto Rico's constitution, as significant as it is, does not break the chain. There's no getting away from the past. And Addie, if you want to say a few words on kind of the really sea change this presented in Puerto Rico conversations around status, I think that'd be helpful for folks. You're muted, Addie.
Sorry. So yes, Neil, definitely, there is a before and after this case in Puerto Rican politics, because in Puerto Rico, which is different from the other territories, our party politics locally, it's not based in conservative and liberal. It's based on pro-independence, pro-statehood, and pro-commonwealth. Those are the three main parties that have existed for the longest time. So when Sanchez Valle, well, since they allowed us, so it would be since the 40s. So when Sanchez Valle was decided, it was a very hard hit for the pro-Commonwealth Party, because basically the leadership of that party became divided even between saying this bilateral accord that we had done through the Constitution is not bilateral at all, and we're basically in a colony. There are others that wanted to stay, thinking that the Commonwealth is still a good option and that the territorial option is a good option, but the whole thing had like a very shaped effect. The other really interesting effect was that pro-statehooders started talking about this relationship as a colonial relationship for the first time. They would usually just defend the relationship and defend the relationship. And so it was just like a very hard hitting moment for the Puerto Rican people. And even new parties started sprouting up. So yes, when they tell us, that the Constitution didn't create any type of autonomy for us, it was very hard.
And it also didn't help that it was followed a few weeks later with the passage of PROMESA, which established the Fiscal Control Board, which, while directly focused on Puerto Rico, the statutory language actually includes all 5 U.S. territories. And that's a board that has powers over basic budgets and expenditures in Puerto Rico, can veto local laws. It's unelected, appointed by the president. It's basically a colonial overseer board. Another case that year, Puerto Rico versus Franklin, California Tax-Free Trust, examined whether Puerto Rico has the power to enact its own bankruptcy laws when federal bankruptcy provisions have arbitrarily excluded them. And the court came and said, no, federal law preempts Puerto Rico from legislating at all in this space, even when Congress does not act or has not acted with respect to Puerto Rico. And again, PROMESA was enacted just a few months later. Going to another case, this is the Fiscal Control Board versus Aurelius Investment. This was the case concerning whether the appointments clause applies in Puerto Rico, and if so, is the Fiscal Control Board consistent with it? And the court answered yes to both. Notably, it expressly did not apply the Insular cases, which it explained, quote, did not reach this issue. It did question, nonetheless, it questioned their continuing validity, citing the plurality in Reed, a case they talked about last week, for the principle that, quote, the Insular cases should not be further extended. So here you had an overwhelming majority of the court expressing skepticism and a narrowing of the Insular cases while falling short of expressly overruling them. And that brings us to United States versus Valle Madero. Can Congress deny U.S. citizens SSI simply because they live in a U.S. territory? And the answer there, perhaps you're sensing a trend, federal government always wins. Yes, under the territory clause, quote, Congress can legislate differently with respect to the territories than it does with respect to the states, based on, I think this is important for the conversation today, the unique histories, economic conditions, social circumstances, independent policy views, and relative autonomy of the individual territories. We'll get into that a little bit more later as we dig into the covenant. In that same case, you had two very important decisions by Justice Neil Gorsuch and Justice Sotomayor. You had Justice Gorsuch write a full-blown opinion, taking on the Insular cases headlong, saying they have no foundation in the Constitution, rest on racial stereotypes, no place in our law, nothing in the Constitution extends to so-called unincorporated territories, only certain fundamental constitutional guarantees. Sonia Sotomayor agreed that the Insular cases were premised on beliefs both odious and wrong. And then that brings us to the most recent of the cases, the Fiscal Control Board versus CPI. This is a journalistic organization in Puerto Rico. It asked, can the board claim 11th Amendment sovereign immunity to avoid adhering to public transparency laws constitutionalized in Puerto Rico's own constitution? So this is like FOIA, but constitutional FOIA in Puerto Rico. And once again, the court said yes to the board, strangely, without even establishing whether the 11th Amendment even applies. Very strange posture. But again, presenting this kind of heads I win, tails you lose dynamic when it comes to the power of federal government over each of the 5 jurisdictions, island jurisdictions.
And I have to say, Neil, that's why we call it the colonial board, because it always wins. And also, I gave the class of colonialism and the board in law school here. And one of the things that really caught my eye before I even met you was that the board law, that the Promesa law has an expression that this law can be used also in the other territories. It applies to all territories. So if other territories go bankrupt or have some issue with bankruptcy, that is the framework that the federal government, at least under the law, is intending to use. So this is something that affects us all in that sense.
So next, we wanted to talk a little bit about some of the areas of difference we had from the conversation last week. And there's really 2 kind of key categories: historical understandings and legal strategy. So there's a common assumption among many that the Insular cases framework serves as a kind of foundation for the covenant, particularly with respect to protections for land, the structure of the NMI legislature. We heard last week that the covenant was, quote, premised on the idea of, quote, constitutional exemptions grounded in the Insular cases, and that these exemptions were, quote, fundamental and integral to the covenant. There was a suggestion last week that without the Insular cases and these constitutional carve-outs, the whole covenant would be, quote, invalid, that there would be, quote, no political union between the CNMI and the United States, that the NMI would, quote, be back at square one, that it would, quote, throw all the marbles into the air, that it would, quote, be a constitutional crisis of unknown resolution, that there's a, quote, great hazard in knocking out the legs from the covenant. Now, these are strong words. They're scary words. But the question we want folks to consider is that what the text and history of the covenant actually reflect? Is this assumption well-grounded? Even my colleague, Jed Horry, seemed to acknowledge that it was, quote, not so much that the Insular cases historically were even the basis of what was done, but rather that they were, quote, the basis of how the covenant has been upheld by the courts. Now, as we're approaching the 50th anniversary of the covenant, it's important to look at both the history of the negotiations that went into the covenant and what the covenant actually says. And I think we can all agree there's some important lessons we can draw from those who negotiated the covenant 50 years ago. So let's jump into that. So this slide shows Eddie Pangilinan and Ambassador Williams, kind of the 2 lead negotiators for the NMI in the United States. And they both spoke directly to the question of the application of the US Constitution. Eddie Pangilinan, who I knew quite well during my time in DC, he was a great man. I've known him since 1998 when I was interning for Robert Underwood. in Washington. I got to know him a lot better when I was working for Madeline Bordalio. Always got the sense being around him, that I was walking around with a living legend. He said, quote, "The people of the Marianas are prepared to embrace the U.S. Constitution and its Bill of Rights." Let's go back.
Yes, I'm trying.
And then Ambassador Williams, who I actually also had the opportunity to meet, and that was a little more of an awkward interaction. It was during a national scholarship interview, which he was on the panel. He argued quite loudly for an incredibly expansive view of federal power over the NMI. I demurred and defended a more robust view of local self-government. Needless to say, I did not get the scholarship. But as he said during the negotiations, protections provided by the U.S. Constitution, quote, "will be no less than that provided anyone living under the American flag." Let's go on to the next slide. So we wanted to look at the text and history of some of the key provisions of the covenant, starting with Section 102, the political relationship, which says the NMI in the United States, quote, "will be governed by this covenant, which together with those provisions of the U.S. Constitution applicable to the Northern Mariana Islands will be the supreme law of the land." In the section-by-section analysis, it makes clear that federal law will control in the case of a conflict between local law and a valid federal law. Let's move on to the next slide. Now, this one focuses specifically on the application of the U.S. Constitution, and it's got some tricky language in it. It clarifies, quote, "to the extent that they're not applicable of their own force, that certain specified constitutional provisions, quote, will be applicable with the Northern Mariana Islands as if the Northern Mariana Islands were one of the several states." Then it goes on to add constitutional provisions which do not apply of their own force, require mutual consent to be in effect. And again, the section-by-section analysis explains that part of the challenge of this formulating the subsection was complicated by the Insular cases. And how I take that to mean was because of uncertainty over which constitutional provisions apply under the Insular cases, the covenant had to make clear that whether the NMI was a territory or not, these certain provisions would apply as if it were a state. So the covenant answers those questions quite clearly. It does not answer the questions of what constitutional provisions are generally applicable to U.S. territories, whether incorporated or unincorporated. And and we can go back and look at a little bit what Neil Gorsuch said in his Valle Madero decision here. That these questions aren't fully answered even today for any of the territories. He said, even without the Insular cases, there remain, quote, "difficult questions about, quote, which of the Constitution's individual provisions applies in the territories and how, that may prove hard to resolve." So exactly what provisions apply of their own force and how, it's a relevant and complicated question, even outside of the Insular cases framework, and one not fully answered by the covenant or federal courts, even to this day. Going on to the next section, it talks about applicability of certain provisions. The Constitution will be without prejudice the validity of the power of Congress in the U.S. to consent to the structure of the NMI legislature, jury trials, and land alienation laws. Again, the history here says quite strongly that this should not imply that the parties believe that these provisions are in conflict with the Constitution of the United States, when in fact they're in accord with the United States. So these aren't constitutional carve-outs or constitutional exceptionalism. This is the negotiators and the covenant making clear that these provisions are consistent with the Constitution. And nowhere is this more important than the next section, 805, the land alienation rules, which authorize the NMI to restrict land ownership, quote, "notwithstanding those provisions of the Constitution, treaties, or laws of the United States applicable to the Northern Mariana Islands, in view of the importance of the ownership of land for the culture and traditions of the people the Northern Mariana Islands, and in order to protect them against exploitation and to promote their economic advancement and self-sufficiency. Again, if you look at the history, DOJ expressed the view during the negotiations that properly drawn land alienation restrictions would be valid under the US Constitution, that the limitation of the right to acquire land would not constitute invidious discrimination on racial grounds prohibited by equal protection. And so again, both in the text of this provision and in the history of the provision, you have the foundation for these laws surviving traditional constitutional scrutiny under equal protection. So this brings us to kind of the next area of difference, when it comes to legal strategy. And we'll talk through how, our view relying on the insert cases is unnecessary, it's unwise, it's in fact dangerous, and ultimately it's counterproductive to self-government and self-determination. Last week it was emphasized that, quote, there's a great hazard in knocking out the legs from under how that was done, and, quote, it would hazard the result to go back and try to do it another way. So we actually agree on that. Where we disagree, as we've just been talking about, is that our view is that the historical record shows that the NMI negotiators actually grounded the covenant in traditional constitutional analysis, not constitutional exceptions of the insert cases, which makes sense. They negotiated this in the years after Reed and Torres, where there were 4 votes to fully overrule the insert cases. And the question was, when would the 5th vote appear? So wisely, the negotiators did not, in our view, lay as the foundation the insert cases in crafting this historic agreement.
Neil,
Moving past, go ahead.
Before you go into that, there is a comment in the chat.
Oh, sure.
And it says the territory clause and the commerce clause are not specifically enumerated in the covenant, but the federal district court has held that this does not abrogate Congress's power to legislate with respect to the NMI pursuant to those clauses. And I have to say to that comment that one of the fascinating things I've learned in studying the history of the covenant was this expression that was done in the Senate when it was being approved about how even if it's called a commonwealth, there is still under plenary power of Congress because it is still an unincorporated territory. So definitely there has been very specific expressions about that.
Yeah, and it actually, the territory clause was very specifically contemplated by the negotiators of the covenant. And moving on to the next slide, we'll address this as a central part of what actually allowed for the covenant to take place was this recognition that Congress already has broad powers to create unique arrangements separate and apart from the insert cases. So if you look at the section by section analysis, it says the territory clause is, quote, the mechanism through which Congress legislates with respect to the Northern Mariana Islands with unique treatment possible because, quote, the scope of the federal government's legislative authority with respect to the Commonwealth and the territories is somewhat broader than it is with respect to the states. So if anything, the territory clause is actually much more of the foundation of the covenant than is the insular cases. Going back to United States versus Valle Madero, you have the Supreme Court very recently citing that territory clause power as a justification to be able to treat territories differently based on their unique histories. You also have case law from other jurisdictions, American Samoa, where they upheld very similar land restrictions there based on, quote, a compelling state interest in preserving the lands of American Samoa. When you read Wobble versus Villacruzes closely, you'll see, is this an equal protection case? I mean, they go through each of the steps of equal protection analysis. They find, quote, a compelling justification for the restrictions, noting the vital role of native ownership of land plays in the preservation of NMI social and cultural stability. So I was waiting for the punchline, constitutional under equal protection. Instead, the court inexplicably pivots and cites the insular cases despite the covenant recognizing the equal protection applies, and despite the Supreme Court having long recognized equal protection as a, quote, fundamental right, or as a right that applies in the territories. So you see how the Insular cases are actually unnecessary to reaching these results, but they're also unwise. And so let's take a look at that. So beyond what I quoted earlier, Justice Gorsuch and Sotomayor both agreed on the following statement. They shared, quote, the hope that the court will soon recognize that the Constitution's application should never depend on the misguided framework of the Insular cases. Just last year, the U.S. Justice Department came out and said, quote, the racist language and logic of the Insular cases deserve no place in our law. And they instructed their lawyers to stop citing to them in that way. And kind of going back to analogy from last week, if what you're sitting on has a shaky foundation, it seems like you should sit on something with a stronger foundation. We can all see the stool legs on this stool people are sitting on. They're cracked through and through. The real hazard, we think, is to insist everyone continue to sit on that same shaky stool that seems on the verge of collapsing, rather than grounding it, as the negotiators of the covenant did, on what was a stronger constitutional foundation. They're not only unnecessary and wise, they're also dangerous. And we've seen how that's materialized in some recent cases in the NMI, also in Guam, where the territorial governments have relied on the Insular cases to try to advance arguments and advance their interests. And in the Davis versus CEC case, you had the CEC arguing that restricting land ownership, quote, was permissible under the Insular cases because the U.S. Constitution does not have the same effect in incorporated territories. You had an amicus brief that suggested that the court employ the Insular cases as a normative baseline to uphold the voting restrictions based on this idea of constitutional flexibility. The problem with this is that it creates a really dangerous framing and assumption that these laws would be unconstitutional if subject to traditional constitutional analysis. And again, this is a framing that the covenant negotiators expressly rejected. This also happened in Guam and its own version of the Davis case, different Davis, similar issues, similar reliance on the Insular cases, and again, the same result. And our view is that those who negotiate the covenant put forth a much more compelling starting point for defending the unique arrangements of the covenant, that they are consistent with the U.S. Constitution based on the compelling purposes they serve, both domestically and under international law, and can be justified under Congress's broad powers under the Territory Clause. Arguing these provisions survive constitutional scrutiny because the Constitution does not apply the foundation of arguments based in constitutional exceptionalism or flexibility is a risky legal strategy. Those who negotiate the covenant knew better. Go ahead, Addie.
Yes, and when we start looking at all this framework that has been developed through time and that gives shape to the relationships that the non-incorporated territories have with the U.S. government, that it structures it, definitely defending the Insular cases becomes counterproductive. For us, the Insular cases will always stand for the excuse to act unilaterally at will of Congress. So the thing that protects the governed from the arbitrary power of government is the Constitution. And we think that that was exactly what the framers of the covenant had very clear. And so the Insular cases standed up on that, standed against that. And that's why people like Congressman Sablan would express if anyone is holding on to these racist insular cases as a way of keeping the Northern Mariana Islands land annihilation laws afloat, they may be holding on to an anchor, not to a life preserver. Also, Professor Cristina Ponsa Kraus, in her article, Insular Cases Run Amok, she's been studying this for years and years. She criticizes this idea of, through the insular cases, creating an extra constitutional area, repurpose these cases, creating an extra constitutional area, because creating the illusion of solitude toward territorial self-determination, lower courts inadvertently and perversely entrench federal power while prolonging the subordination of territorial inhabitants. All of this repurposing has left untouched, if not ever more deeply entrenched, the permanent colonial system that the insular cases created. We see it as an opportunity. We see it as an opportunity when we fight against these insular cases. It's not because of the insular cases' sake. It's because it is a form to come together as territories to have the U.S. reckon with this unilateral colonial way of governing over 3.6 million people in the insular areas. And it's an opportunity that we want to be able to promote with all of you. And there is some time for questions and answer, and we want to keep talking. We will be developing on the next few months. We already started with American Samoa, a building and understanding series, because definitely each territory has its own perceptions and fears about what changing this colonial rule or changing the category from unincorporated territory to a regular territory, what this would entail. And there is a lot of presumptions. For example, in Puerto Rico, the application of federal taxes was one of the big fears. We wrote a whole memorandum that Neil worked with. I forgot the name of the other professor, Neil, but there's a whole memorandum on that. We are doing the Building and Understanding series, started with American Samoa, then we will continue with the other territories, and we are going to be visiting the territories again this year. So a lot more opportunities to build this understanding together.
Yeah, so I see a question already. Let's just jump into it, and we're happy to stay as long and take as many questions and hear as many comments as folks have. So, Richard, you've touched on, I think, probably the hardest question on these topics. If the
Do you want to read the question,
Neil?
I'll
read it.
So
if the
that
cases were overruled and a criminal defendant were to demand a jury trial on charges did not get a jury trial under CNMI law, on what basis could the federal court find that the Sixth Amendment jury trial right doesn't apply in the CNMI? And then a follow-up, what would this mean for the other, quote, carve-outs in the covenant? So the jury issue is the trickiest, in part because it's been a tricky issue for the Supreme Court. So when the Insular cases were decided, the right to jury trial had not been incorporated against the states. When the covenant was negotiated, I believe it still had not by that time, or if it had, there were still questions, or I think it had, but there were still questions about exactly what the scope of that right meant in the states. It wasn't until just a few years ago, I think in the Ramos case, where the court started providing some guidance in terms of the scope and nature of what that right means, even with respect to states. Things like the grand jury trial have still not been incorporated against the states. So, this has been a moving target since the Insular cases, really all the way up until today. So I don't have a great answer on what lower court or the Supreme Court would do if addressed with this. But you could see different examples of that. You could see it working out a few different ways. And I think as Jed said last week, unclear that the jury trial issue is really kind of the core or foundation of the covenant, the same way the structure of the government or the land ownership rules are. Other questions, either in the chat or if someone wants to go off mute and ask. Yeah.
Jed has a question, Neil.
Yeah.
Without the insular cases, how do we get exceptions to the Constitution if we want them?
And so again, I think that exceptions is kind of the wrong word to think about. I mean, the Constitution doesn't apply exactly the same in the territories as it does in other parts of the United States, like based on its text and history. There's just different provisions like apportionment, that specifically references states that doesn't apply to the territories. And as Neil Gorsuch said, there's difficult constitutional questions that can and should be asked and that remain unresolved. And that's going to have to be taken up on a case-by-case basis, but based upon what the Constitution says, not based upon this kind of ambiguous doctrine of the insular cases that, again, I'm not aware of a single case where a federal court has relied on the insular cases to rule in favor of the interests of the people of the U.S. territory over the interests of the United States. And so, sure, there could be a hypothetical talked about last week. Well, let's get Congress to say the Second Amendment doesn't apply. Let's get Congress to, whatever other parts of the Constitution you don't like, let's get Congress to do that. I think politically, that's pretty, I guess getting anything done in Congress these days is pretty fanciful. But getting something like that done seems a little fanciful. And then the question on Jed asked a question about the Senate, and again, I think the negotiators were very intentional in how they structured that provision, talking about it as a core aspect of the agreement. Equal protection it's not a binary, on-off thing, the way some other parts of, it's like if the covenant said there will be a king of the NMI who will rule over all the inhabitants, like a title of nobility or something. Like that's something that I think that would be clearly unconstitutional. Once you start getting into equal protection, my experience certainly has been, and Jed, I guess yours as well, in your case, the courts seem to go out of their way to uphold whatever the federal government seems to want. And that was a provision that the federal government agreed to. That was a core part of the covenant. I really don't see them. I really don't see federal courts acting against that on any constitutional theory.
I want to think about that question the other way around. With the insular cases, it is only the United States governments who can make exceptions to the Constitution. They do it all the time. By applying the insular cases, they say you can be accepted or excluded from a constitutional right that is generally accepted for all the other people residing in the states. So the ones that do get exceptions because of the doctrine of the insular cases is not going to be us. It's going to be the U.S. government and has done it repeatedly.
Other questions, either in the chat or if you want to say them on the mic?
Mr. Richard Miller. Oh, thank you, Mr. Miller, for being here. Appreciate it.
And I guess one question for the bar on Sanchez Valle. I was talking with one of the scholars I work with on issues of criminal procedure in the territories. And I was asking him, the theory under Sanchez Valle of dual sovereignty, is it perhaps a different result in the Northern Mariana Islands because of the covenant? There's a federal statute that doesn't allow for concurrent prosecution in Guam, the NMI, and the VI, but it doesn't specifically mention the Northern Mariana Islands. If indeed the covenant stands for what many would like it to, is the United States Justice Department office in the NMI, in Guam and the NMI, recognize that locals could prosecute. I don't know if there's a statutory answer to that. Is this an unanswered constitutional answer? Is it something that, as a matter of practice, maybe for ages, they've just been deferring to each other anyway out of convenience and efficiency? But I think it is an open question on whether Sanchez Valle really applies the same way in the NMI, the way it does, and certainly in Puerto Rico, but also the other territories.
Mm-hmm. Mm-hmm. And
Mr. Baca, so are you saying that there could be concurrent prosecution by local prosecutors and federal prosecutors on the same charges? And if one was found not guilty, the charge could proceed in the other case. That's really interesting. I might put my colleague in touch with you if you don't mind.
That is very interesting. I also wanted to expand a little on that. Many times, and it happens here in Puerto Rico too, when we're talking about the application of constitutional law to us, is that we're always thinking of U.S. constitutional law like something that doesn't have any relationship with the concept of human rights and fundamental rights internationally. So the concepts of our Constitution being the document that protects the people under the sovereignty of our government is a concept that is per what the modern state is, and that is based on some very fundamental principles that apply universally. So equal protection of the law is not a concept that le pertenece, that is owned by the U.S. government. It is a concept that has a much more fundamental content that goes beyond that framework of the U.S. Constitution. And I say it because the U.S. has, and this is, I think, something that we as territories need to push more, has acquired or has committed to international law that explains and builds these concepts in a much broader way than just the limited case-by-case that has been developed by the Supreme Court. So just kind of like not to just see it in that narrow scope of our existence. Our relationship with the U.S. should be grounded on these principles, not only because of their structuring, the constitutional structuring as a nation, but also because of their commitments with international law. These are not different.
And maybe to end on a positive note, I think, Jed's invocation of that in his petition Supreme Court in Solace was prescient and, an area of common ground. We'd love to see CNMI bar resolution focused on questions of self-government and self-determination pertaining to those issues raised in that cert petition. And, would see many folks in the other territories standing alongside something like that. So I think there are a lot of really overwhelmingly areas of agreement, at least in my mind, even as there are some differences maybe on historical understandings or legal strategy. It really seems like a lot of the goals are the same, of promoting self-government, promoting self-determination, and just recognizing, and someone said last week, well, what does Neil want? It's not, I don't have a want or desire, one way or the other on status, or, I don't want the Second Amendment to apply or not apply. I don't take a view on that. But the United States has taken views on this. They have explained what they believe and understand the relationship to be. And that understanding has been backed up by federal court decisions that people in the NMI have had to follow. And over the last 20 years, it's significantly eroded both through congressional action and federal court action, self-government and self-determination in the NMI, and really across all the territories. That when I started working on these issues, 12, 15 years ago, the relationship looked very different than it does now. And I think people now see how imbalanced the relationship is and how much it favors U.S. interests first, second, and last over the interests of folks in the territories when push comes to shove. So I think there's a lot of common ground we have. Excited to continue working together, talking together. 50th anniversary of the covenant.
I wanted to
Yeah, go ahead.
close with a small comment about
Sure.
this dual sovereignty that Mr. Baca mentions. This is why I admire so much the covenant and what you guys achieved, because it is so strong as a bilateral agreement than any of the other instruments in the other territories. And that is what should be protected. It should be protected as a bilateral agreement that has produced this relationship of dual sovereignty. The insular cases are not the instrument to do that. It's not what will serve to do that. What serves to do that is the nature of the covenant as a treaty that you guys were able to negotiate at that point in time. And that is what is so valuable in that, that should be celebrated.
Well, thank you all very much. Thanks, Charity. Thanks, members of the bar. And look forward to talking more about this. We'll share some more materials. We'll share the slides and some other materials, and hope to be back in the NMI later this year, probably both of us, and certainly next year as the covenant anniversary is celebrated.
Thank you so much, everybody. Thank you,
guys
Charity.
very much.
Thank you, the Guam Bar.
Thank you, guys. Have a good night for you.
Good night. Thank you.